Good evening, folks, and good morning for those of you who are in the US or in other time zones. Good afternoon. Welcome to the webinar on the recent Indian Supreme Court judgment on taxation of software. My name is Raman Roy, and for all my sins, I happen to be the regional president of NIC for Indo-American Chamber of Commerce. So welcome. We have a great panel, and Asim is going to moderate it, and he will shortly introduce the panel. Just a few minutes to give you my understanding. I'm perhaps the only non-lawyer, I was going to say non-lawyer, non-accountant in this meeting. There may be a whole lot of other accountants. I'm also an accountant, though not a practicing accountant. But I'm also a member of the Indian IT industry that imports and uses multiple hardware that are embedded with the software. And quite honestly, I'm very enthused by this decision of the Supreme Court, because it is something that had been hanging fire. So, while we talk of our companies and buying equipment that is embedded with software, let me share with you a little story. Motivated by my dear daughter, I bought a hybrid car so that I could help the environment, lower emissions, lower fuel utilization, and all those good. And one fine day, that hybrid wouldn't start. We tried everything. The neighborhood mechanic told me he had no idea of how it worked, and we actually went to the manufacturer. It was from Toyota. They got somebody to come and start the car, and they said its software requires an upgrade. And I said, "You're kidding me. It is not starting. It is not any other issue." He said, "Yeah, you need a software reload." And they took the car away and, redid the memory, redid the software, reloaded, and bingo, it started working again. That is when I realized that even the car today has embedded software. And the embedded software is not only in the B2B industry, but as applicable in B2C. Software as a service is a new reality. I'm very active in the startup world. I'm a co-founder of the Indian Angel Network, and I can tell you that we have more than 20 companies that are offering software as a service, which we are helping promote and take it to the next level. And COVID and the lockdown, and those of you who are logging in from parts of India where different timing of lockdowns are in play right now, you'd understand some of the aspects of how working from home has become a new reality. And in that, software plays a huge role. Software as a service will grow dramatically, in my opinion, and different business models will emerge, which will have different kind of revenues in which they are charged. And particularly due to the digitization of the business, this will have a huge impact of what the Supreme Court decision means and where it goes, because a lot of the hardware and the software actually comes from overseas. And the taxation impact will definitely have some impact on which way this segment grows. The controversy was essentially about the taxation of software payments as royalty or business income in the non-resident taxpayers' hands. The high courts had given divergent decisions, and I'm told that there was a batch of 103 appeals that was pending before the court for a decision on the issue, filed either by the Revenue Department or taxpayers as a result of this dichotomy in the various decisions of various high courts and the position taken by the tax department. The Revenue Department had taxed payment as royalties under the Income Tax Act and relevant agreements for the avoidance of the double taxation, the DTAs, as it believed that the transactions involving a transfer of copyright. Taxpayers, however, claimed the payments as business income, and this had the link to it, the TDS implications of where TDS had to be deducted or did not have to be deducted. On March 2nd, 2021, barely 1 month and 18 days ago, the Supreme Court of India delivered a landmark ruling in the case of Engineering Analysis Center of Excellence Private Limited. The judgment settled a long-running contentious issue over how payments made by Indian customers to non-resident suppliers for the use or resale of computer software should be characterized, providing the much-needed tax certainty on the issue. The court's first task was to analyze the Copyright Act in the cases before it to establish whether there was a transfer of copyright or not. I'm not competent to go into gory details, so I will avoid trying to look like a fool by going into details of that. The court observed that a copyright is an exclusive right that restricts others from doing certain acts. It noted that a copyright is an intangible right in the nature of a privilege entirely independent of any material substance. And that, for me as an IT industry member, is the core part of the excitement. Owning copyright in a work is different from owning the physical material in which the copyrighted work may be embodied. Computer programs are categorized as literally work under the Copyright Act, and the Copyright Act states that copyright is an exclusive right to do or authorize the doing of certain acts in respect of a work, including literary work. The court observed that the transfer of copyright would occur only when the owner of the copyright parts with the right to do any one of the acts that are mentioned in Section 14 of the Copyright Act. The right to reproduce a computer program, that is what people within my industry do a lot. The right to reproduce a computer program and exploit the reproduction by sale, transfer, or license is the computer program owner's exclusive right. In addition to making copies or adapting a computer program to use it for the purposes for which it was supplied, or to make backup copies as temporary protection against loss, destruction, or damage to use a computer program, does not constitute an act of infringement of copyright. The court held that the license from a copyright owner conferring no proprietary interest to the licensee, like as a car owner, I do not have the proprietary interest in the software of the car, does not involve parting of any copyright. It said this is different from the license issued under the relevant section of the Copyright Act, which grants the licensee an interest to the rights mentioned under Section 14 of the Act. As such, what is licensed by the foreign non-resident supplier to the distributor and resold to the resident end user or directly supplied to the resident end user is the sale of a physical object which contains an embedded computer program. Therefore, this is sale of goods. As the end user gets only the right to use the computer software under the non-exclusive agreement, ensuring that the owner continues to retain the computer software. The judgment finally settles, in my opinion, and you will hear our extreme panelists talk about it, a long-drawn dispute on the taxation of cross-border payments and makes it independent of the mode of delivery. In short, the SC judgment is a welcome realignment of the international customary law in India's international tax policy. One would hope that the government would respect the verdict and abide by it in letter and spirit, thereby bringing this 2-decade-old dispute to a closure, which, as the court at the start of the judgment observed, have a checkered history. So folks, welcome to this session. We have a great panel, and to introduce the panel and take it forward, I hand you over to our moderator, Asim Chawla.
Thank you, my president. And this is the maximum I've heard from you in terms of taking you back to your accounting or an accountant avatar. So to that extent, you owe it to our committee. And I am very happy to get your accountant sort of back into your verbiage. Maybe the topic is such that we make it sound very exhilarating, and I'm grateful for your continued patronage. Well, ladies, gentlemen, friends, colleagues, whichever part of the world you are in, and I know you are more than 125 already logged in. We welcome you to this dipstick on the recent Supreme Court decision. I am extremely privileged, along with my co-chair, to introduce Jed Rogers from United States. He much like what you heard from my regional president saying that the judgment has checkered history, Jed himself has a very checkered and accomplished background. His advice on inversions, M&A transactions, especially ABP 23 positions, FIN 48, and on a closer academic note, he has a perfect blend, has a bachelor's in economics from Boston, a JD from Roger Williams Schools, Masters of Law again from Boston, and he's licensed to practice in Georgia and New York. Jed, thank you very much for taking time out and being with us. I know for a fact that you've been in-house IBM, but and all your comments are in your present capacity. I understand out of 100 plus matters, IBM was a batch matter on their on this entire EULA, which you heard from Raman. And moving over, well, it's a great privilege and a matter of personal delight for me and my co-chair Sachin to welcome a very distinguished Mr. Pramod Kumar, who's currently the Vice President of Income Tax Appellate Tribunal. He is a chartered accountant by education and has been at the benches for over 2 decades now. Well, all that I can say is that if there is one authority in our country who can write with extreme amount of flair and conviction on international tax matters, it is Mr. Kumar. He is very well known in India for his outstanding work on international taxation. His orders are seminal, which finds mention. If you're learning international taxation, well, you will stumble upon the orders which acclaim his academic interest in the subject. He's participated in large number of conferences. Importantly, he was the director of International Association of Tax Judges, which was set up by Tax Court of Canada, and there is something where we will certainly rely on his experience in terms of what should be the crystal gazing in terms of India's outlook towards international taxation. I was telling him a little earlier in our quick just before joining that we have this very uncanny simile, Jed, of bringing the cricket into it, and I know we're trying to popularize this sport in America also. Well, if I had any simile to describe, pardon me, sir, your lordships, I will rather say that, well, he is Mr. Viv Richards of Indian international taxation, very, very flamboyant, has his own mind, tremendous conviction, and extremely grateful to you. In terms of our minute-to-minute program, we've requested Sachin, who is my Mr. Dependable, to just quickly set the tone in terms of spending few minutes taking through the judgment very quickly, and then we'll ask Jed for his remarks. All that I can tell you, both our experts, including our chief guest here, Mr. Kumar, have spent a lot of time with us in terms of the preparatory session which have gone into it. We've had 2 or 3 rounds of discussion. So we bring you here not only the analysis and takeaway, but we bring it to you with a lot of purpose and time. And I am extremely grateful to both of them for it. It's just that the background skyline of Sir as well as Jed does suggest that you are competing for some skyscrapers, but that I leave it to it a little later. Sachin, over to you very quickly in terms of our allotted time, and then we'll ask Jed for his thoughts on this.
Yes, thank you, Asim, and good evening to all. These times are very, very difficult and challenging, and I hope each one of you is keeping safe, doing well, and really, thanks to everyone to join in at this hour. I have started sharing my screen. I should have to probably just bear with me for a couple of minutes. Yes, I think now it should be visible.
Yeah.
Yes. So, there I drustai.
Sachin, go into presentation mode, please. This is not in presentation.
Sir, I have gone into presentation mode. I think it should.
It went away.
Okay, just allow me a minute, sir. Yes. So while I'm fixing the screen share, we can still start. So as I was saying, there I drustai, or maybe better late than never, or whatever you may like to say. So it has taken almost 20 years for this matter to be finally settled by the Honorable Supreme Court, but it has been worth the wait. So I've been given 15 odd minutes by my captain to explain a 226-page judgment. So while I have tried to capture all the important aspects of this judgment, but if I have left out any aspect, kindly bear with me.
Sachin, you have to improve your audio. We're getting comments that you have to be a little louder.
Okay, sure.
And your 15 is now crippled to 12 because the coach took a little time. So try and hurry up in 12.
Sure, will do.
This captain is very tough, Sachin.
Doesn't matter, sir. It is always good to have tough captains.
Okay, yeah, the presentation shows well. Thank you.
Lovely, lovely, lovely. So this was a batch of 103 matters wherein various courts had taken a different view that whether the purchase of software from a foreign company amounts to royalty because of the transfer of the copyright. And the case that was picked up for this particular judgment was in the matter of engineering excellence. So the facts of the case were that the taxpayer, being an Indian company, imported shrink-wrapped software from a foreign company and made payments without deduction of tax at source. The AO held that the foreign company had transferred the copyright in the software, and therefore the payment was for royalty. And the company was held to be a company in default. And this finding of the AO was finally upheld by the Karnataka High Court as well. Now, the Supreme Court, after going through all the business models in the cases which were listed before it, categorized the taxpayers into 4 buckets. So the first was sale of software directly by a non-resident to an end user in India. Sale of software by a non-resident to an Indian distributor for resale to end customers in India. Sale of software to a foreign distributor for resale to end customers in India. And sale of software bundled with hardware by a non-resident to Indian distributors or end users. Now, as many of these cases under consideration dealt with Section 195, the argument of the revenue was that for the purpose of Section 195, you cannot look at the DTAA. And for this proposition, they relied upon the decision of the Supreme Court itself in the Pilcom case, where the court, for the purposes of Section 194E, based on the language used in the section, had taken the view that the benefit of the DTA cannot be given. But in this case, the Supreme Court, after extensively considering the Section 4, 5, 9, 19, 195, held that once the DTA is applicable to the taxpayer, the provisions of the Act could only apply to the extent they are more beneficial to the taxpayer, and that the machinery provisions of 195 are inextricably linked to the charging section of 4, 5, and 9. And the court relied on its own previous judgments in the case of GE Technology Center Private Limited and Vodafone International Holding to arrive at this conclusion. Further on, the court then went on to distinguish the Pilcom ruling, where they observed that under 194E, the section uses the words income payable to a non-resident, whereas in 195, the heart of the section is the expression chargeable to tax. And there cannot be a determination of a sum chargeable to tax without a reference to the DTA. And therefore, the court negated the argument of the revenue and held that DTA has to be considered at the time of withholding. So the next came the question of royalty. So the court looked into the explanation 4 to section 90, and it found that that explanation says that if any term used in the DTA is defined therein, the said term shall have the same meaning as assigned under the DTA. And if a term is not defined under the DTA, but defined in the Act, you would give the meaning ascribed under the Act. The court also referred to Article 3.2 of the DTA, and in this case, it was the India-Singapore Treaty. And they noted that 3.2 provides that any term not defined in the DTA shall, unless the context otherwise requires, have the same meaning which it has under the laws of that state. Now here, the court was concerned with the question of whether the payment for software constituted payment for a copyright, because royalty, in its definition under 916, covers the transfer of a right in respect of a copyright. The court further observed that copyright is not defined in the DTA nor in the Act. So as you all know, that a right actually arises from some backing of some law. So if you have a fundamental right, it comes from the Constitution. If you have a legal right, it'll come from that particular law. So how do you get a copyright? So the court said that the only way you get a copyright is by virtue of Section 16 of the Copyright Act. And therefore, in order to know what has been transferred is whether a copyright or no, you have to look at the Copyright Act. So that's why the court dwelled into the nitty-gritties or the niceties of the Copyright Act. The court, after extensively going through the various sections of the Copyright Act, held that the owner of a copyright has an inherent right to make copies and distribute his work, and that the Act itself makes a distinction between a copyright in a work and a copyrighted article. The court further referred to section 14b small Roman 2 and observed that it is when for the first time the copyright owner parts with his distribution right in the work, his right gets exhausted, and therefore a subsequent sale by the distributor does not amount to transfer of a copyright. And they explained this concept under the doctrine of sale and relied on the Delhi High Court judgment in the case of Warner Brothers to drive home this point of doctrine of first sale. Now, having gone through the Copyright Act, the court then further went into the various EULAs which had been entered by the users of the software with the companies which had actually provided the software. And they noted across the various business models that the distributor was granted only a non-exclusive, non-transferable license to resell the computer software. And it was expressly stated that no copyright was transferred to the distributor or end user. No right was granted to the sub-licensee or transfer, modify, and reproduce in any manner otherwise as permitted. The end user could only use the computer program by installing it in the computer hardware and could not reproduce the same for sale or transfer. Therefore, the court came to this conclusion that no right was granted to reproduce the computer software under the Copyright Act section 14A and 14B. It accordingly distinguished the right to reproduce and right to use the software, and finally came to the conclusion that what was paid for by consideration by the distributor was therefore the price of a copy of the computer program as goods. So, be it a case of a distributor or directly an end user importing the software, the court held that the payment made for such software did not constitute any transfer of a copyright, and hence there was no question of any royalty. The court thereafter took pains to demolish the argument of the revenue that explanation 4 inserted by Finance Act 2012 was clarificatory. The court noted that explanation 3 to section 9, which uses the word computer software, only first time included or inserted the term software in 1491. And in the Copyright Act, the words computer program were inserted in 1994. So how could an explanation deemed to take effect from 1676 when the relevant words in the Act were only used much later? So the court held that that explanation was not clarificatory and it was substantive in nature. It further held that the obligation to withhold tax in case of a retrospective amendment is not there. And for this purpose, it relied on this Latin maxim, lex non cogit ad impossibilia, that the law does not demand the impossible. And during the course of the judgment, and while arriving at this conclusion that there is a difference between a copyright and a copyrighted article, the court relied on the OECD commentary. So the ASG, who was arguing for the revenue, pointed out that India had made a reservation on the OECD commentary. So the court negated that argument and held that India's reservation on an OECD commentary is only a unilateral view which cannot override a bilateral treaty. Now, we have this judgment in place, but a lot of interesting issues arise post this judgment. Now, assuming you are a company which has withheld tax, but have not filed an appeal under 248, because 248 requires that you pay tax and then go to the CITA. Can this judgment be a justifiable reason to condone the delay to file an appeal under 248? Or can you take the recourse to the circular of the board, which is 7 number issued in 2007, to claim a refund? If you're a non-resident and if your matter is somewhere in the life cycle of this entire litigation, then of course you can stake a claim for a refund if that income has been offered to tax. Now, this will also depend what the non-resident has done in his home country. And if a return has been filed and no proceedings are pending, can you file a 154? Because non-consideration of an order of a Supreme Court does amount to a mistake apparent from record, as was held in Saurashtra Kutch case 305 ITR. Or can the delay in filing a 264 be condoned because of the Supreme Court judgment by taking recourse to Karamchand Premchand 101 ITR? And if no return has been filed, can you approach the CBDT under 119 to extend the time? And finally, this whole interplay between the equalization levy and the domestic law. So once section 163 under the equalization levy was amended by Finance Act 2021, wherein a proviso has been inserted that if any income or if any payment is characterized as royalty, which is the nature of, so any payment for a service characterized as royalty is outside the scope of equalization levy. Now, with this judgment, if you are outside the scope of royalty, you get exposed to or you are vulnerable to be caught in equalization levy. So this whole interplay between EL and the domestic law would now assume significance. So with this, I come to end of this small PPT which I had prepared. Thank you for a patient listening. Asim, I hope I have done justice to this Supreme Court judgment in the given time. Back to you.
Thank you, Co-Chair. Sachin, such a pillar of strength you are always, and as I keep on saying, you bring a lot of gravitas and sanity. Thank you for this great summary, and I think it just sets the tone for us to take it forward from here. Just keep an eye, as always, you are dependable on the chat box for some questions which we will get. We are about 150 plus at this point in time in terms of our count. So Jed, let me, without much ado, first of all, congratulate you. The new Biden administration has the first woman or lady who's the Treasury Secretary, Janet, and more importantly, the first person of color who's the deputy at AMO. And we always make it a point when we get very distinguished speakers like you to not only spend some time on the subject, and I must thank you for the time which you took out in terms of prep session and rightly pointed our thoughts in terms of the real business as to what happens to things like credits. Is there the tax which has been withheld, does it stand locked up? So those practical considerations are important. And also our discussions with regard to US 368 regulations, etc., would be very helpful. Towards maybe we've requested you to spend about 20 minutes on this. Towards last 5 minutes, I would also request you to spend a little more time on the implore which is coming from the Biden administration with regard to the minimum corporate tax and 28%, whether this 28% is, looks like a serious stuff being promulgated by the White House. And if that be so, how does the world react to it? I think that would be some fascinating takeaways from you in terms of, again, whether it would make the US companies less competitive, which is not the case as the administration says. And also, let's say some industries are claiming tax holidays, what happens to them? And that's one part of it. The other part of it is, of course, the dogfight which is happening in terms of race to the bottom. And as Secretary Yanet said that, well, we wasted 30 years on this, and let's get going on this. So your thoughts would be most helpful. And thank you once again for making it. Extremely grateful to you.
Yeah. Hey, everybody. Thanks for having me all. Happy to be here. Welcome the opportunity to talk, and much appreciate everybody listening on this fairly important matter, which I guess has really evolved since I was a junior tax practitioner back in my IBM days, like Asim mentioned earlier. Even when I was just starting to practice tax, I remember one of the first items that came along when I was working at IBM, obviously is a fairly large, or one of the largest software companies in the world, which sometimes people don't realize that, at least IBM in particular, that while most of their software is in the quote unquote middleware space, it's not applications that you would see on your desktop, or it's not operating systems, although they do have some. Largely their revenue is generated by, at least at the time, was middleware software, which just kind of makes the operating system talk to the applications in the output. But they generate significant revenues. And just to give you a little more color, so one of the first things that when I joined, we had a distribution network all over the globe, of course, with respect to our software revenue generation. And of course, India was high on that list, along with other Asian countries. And we constantly dealt with, whether it was in India or other jurisdictions, the withholding issues, and the cash costs associated with it, and if we were subject to withholding, how that would impact the U.S. tax return. So it's interesting to see this involve on the Indian side in the recent judgment, because as I think about it, and I'm asked to speak relatively from a U.S. prism, we in the U.S., going back to 1998, have what these, at least, and they've evolved recently. There's been recent changes to take into account some of the new, a lot of the SaaS that's out in the marketplace, and other digital content in the form of things like iTunes and that kind of a thing, where it's copyright protected, but it may not necessarily be software. So we've come a long way in the States, but going back to 1998, we have these 861-18 regulations, which exactly discuss this type of an issue. In particular, that's being adjudicated in India just now, which really honed in and focused on, just like the jurisdiction, the case does, on, well, what's the distinction between the transfer of a copyright right by a non-resident to a resident in India, whether it's a distributor or an end user, and what's the transfer of a copyrighted article? Because obviously that's the fundamental distinction for purposes of whether or not you have a license generating a royalty subject to withholding tax. And as the case effectively does, it piggybacks off similar kind of a construct, that it looks to, as articulated by Sachin, does the license grant and license in name only, that's for the IP protection itself, but does it grant the right to copy and distribute from the non-resident to the Indian, whether it's a distributor or end user? Can you make derivatives of the underlying program? Can you publicly perform and display for purposes of not advertising, other than the advertising space. Those are the kinds of items, when you really boil it down, that when you're executing a software transfer by a non-resident to a resident, that could dictate whether or not that transfer is going to be a license subject, to a royalty payment, which would then be subject to tax, withholding tax in India. So that's, at a high level, that's generally the kind of things that we would, even going back to my early days at IBM, we'd be thinking about in terms of, what, if anything, maybe be subject to withholding, and how do we want to construct our either end user license agreements or distributor agreements such that these, in particular, these rights are not granted to the individual or the company in India who's going to be making the payment, so we can otherwise avoid this, sometimes fairly onerous withholding tax. And it's interesting because it's further evolved after the release of the 1998 regulations in the US. Then there was OECD commentaries, which basically effectively piggybacked off the US construct, and then it adopted, for all practical purposes, the similar legislation that was in these -18 regs in the US. And a lot of jurisdictions also followed that construct, but a lot didn't. In the case in the Indian judgment, of course, there's reference to the fact that in the OECD commentaries, India had initially had reservations, and they reserved the right to continue to treat payments as royalties subject to withholding, notwithstanding some of the guidance in the preambles to the OECD commentary to Article 12 under royalties. So it's interesting to have, for me as a U.S. guy and U.S. practitioner, to see this evolve over time. And there's a lot of companies certainly that, as they've gone into the Indian market, a quite large market, have been having to wrestle with this issue for a number of years. Like I said, for IBM, going back to really the early 2000s. So as we get down into the nitty gritty, and now we seem to have, finality with respect to the issue, as I think about it from a U.S. perspective. Okay, now the judgment tells us, with the application of treaty, if structured properly, well, you're probably not going to have a license transaction and a royalty subject to the holding. You can have, quote unquote, a sale of software, which is business profits, not subject to withholding. Well, many taxpayers that are U.S. multinationals inbound into India for purposes of distribution and accessing the market, now all of a sudden they find themselves in a posture where it may be the situation where withholding was prior provided for, and the taxpayer took a U.S. federal income tax withholding tax credit on their U.S. tax income return. So they're crediting whatever their pre-credit U.S. income tax is with, say, Indian withholding tax, and probably in a prior period, because this has been going on for years. So now they find out that, okay, well, the judgment is out. There's some level of finality to it. Is it reasonably certain that I could get a refund with respect to those withholding taxes, and what does that do to my foreign tax credit? So interestingly enough, likely it's the scenario there is, that could very well be true. Whereas while you took a foreign income tax credit in a prior period, you could now all of a sudden not be entitled to it. So, because the rule and the standard is, if that refund could be reasonably certain to be obtained, then you can't take a credit on the federal tax return. So if you had a withholding in, say, 2020, or 2018, and the refund was reasonably certain, say, in 2021 as a result of the judgment, there could be an issue with respect to the filing of that 2018 tax return and the credit that was taken. And as part of tax reform, there's what they call these foreign tax redeterminations that would otherwise require a taxpayer to amend their tax returns in the year to which the tax relates. So it's part of the legislative change in 2017. It's created a significant amount of complexity and compliance for U.S. taxpayers, and now they're in a posture where once the judgment comes out, come to find out we weren't maybe entitled to take a foreign tax credit because of the possibility of a refund of the withholding tax. Well, what does that mean? So let's say I get a refund hypothetically in 2021. It relates to a withholding tax in the 2019 year. Now taxpayers are under an obligation to, with their 2021 tax return, go back and file an amended tax return with respect to that 2019 period, and the impact that what that could have being not otherwise entitled to a foreign tax credit because of the likelihood either when if you do obtain a refund, or the likelihood that you could otherwise obtain a refund even if you hadn't applied for in and of itself. So there's a lot of, even just from a compliance perspective and kind of mechanically, when you think about, what does this mean for a U.S. multinational accessing the Indian market in the software space? What do I have to do in terms of, the cash costs associated with the withholding taxes, and how does that feed into my U.S. federal income tax return from a foreign tax credit perspective? And that's true with respect to not only U.S. non-residents or to India selling directly into India, but also a lot of U.S. multinationals. A lot of clients of mine now, or even IBM in the day when I was at IBM, they don't typically distribute software into India through the U.S. A lot of times it's regional hubs, regional principals, supply chain structures. They may be taking the software down from a Netherlands, an Ireland, in and through India that way, or a Singapore, or another Asian regional hub. And these principal structures, obviously everybody has heard from them at this point, and they're in the news constantly, and they're kind of a political football because of the IP ownership and everything else and the savings associated. But the premise is still there. It still holds true, even as I think about it as a U.S. practitioner. Those entities that are in their legal structure and that are controlled entities by the ultimate U.S. parent, the issues with respect to the possibility of a refund and how that is impacted with respect to the foreign tax credit on the U.S. tax return and the requirement to amend in the prior period to which the withholding tax related. That all still holds true, and we'll get to it a little bit more, but that's really largely as a result of now the fact that these foreign principal entities that are in the group structure are all subject to these anti-deferral provisions, namely one being subpart F, which people usually in these structures have structured out of, but now most importantly, the GILTI regime, in which in the US, without getting into the nitty gritty, all those foreign earnings are immediately subject to U.S. tax at the U.S. taxpayer level, at the U.S. corporate level. But there's also come with a foreign tax credit. So, and how that credit is impacted with respect to any potential for a refund as a result of the new judgment certainly is something to be thinking about, and how that goes into the meat grinder. I'm working with a client now who, not in this necessarily in this context, but it's a fairly large undertaking. So that's one of the things from a U.S. lens I wanted to note, that it can be quite painstaking to have to both, to go back and amend prior returns prior to reform in 2017, when you had a refund of a tax or you owed otherwise tax on assessment and you had the foreign tax redetermination. You would just update your foreign tax credit pools, update your earnings and profits, and effectively roll it forward on a go-forward basis. Those days, unfortunately, over. So there's basically going to be a cottage, and they're already starting to be, the cottage industry of taxpayers having to go back and continuously amend for, whether it's an Indian withholding tax or any other withholding tax or any other tax they incur in a foreign jurisdiction, if it impacts their U.S. tax liability. So it can really turn into a significant number of amended tax returns, even within a given year or multiple years, based on your foreign activity. I mean, India will be no different in the context of, refunds are reasonably certain to occur as a result of the judgment. You could have multiple years where you're amending, going back a number of years, if they're in particular still open under the statute of limitations under the with respect to the return. So it's interesting to see as this has kind of evolved, but certainly while there's opportunities for refunds, there also is, at least on the U.S., there is some challenges with feeding that through the U.S. tax return, because some taxpayers might even, in all honesty, say to themselves, well, geez, I got a full U.S. income tax credit on my, so I don't really care about that withholding as much, at least from a cash perspective, because I paid it, but then I fully effectively offset my federal U.S. income tax dollar for dollar. So on a cash basis, I come out no worse off. Well, the point to make there is under the fact that it may be reasonably certain that the refund could be applied for and obtained. Well, you may not have the ability in that prior period to even take the credit anymore. So now all of a sudden, under audit or in a possible assessment by the IRS, you're almost, and it may be in a way, forced to have to go back and ask for the refund. So you don't have that cash cost, collect the refund in due course, but then also go back and amend that federal income tax return. So certainly a couple things to keep in mind as this all kind of plays itself out operationally, and people are starting to think about refunds and obtaining those. Certainly stuff that can get quite complicated, and the compliance aspects can be, fairly painful, most certainly. Those were the big items I had when I was thinking about this from a U.S. perspective and a U.S. lens. So I wanted to hit on those, certainly. Turning to the, I guess, U.S. tax reform really quickly, as we start to think about what has been coined by the Biden administration, the Made in America tax plan. I mean, that's, I guess, up for debate in many respects. The detail is scant at the moment, not surprisingly. There's a lot of ongoing discussion down in Washington. I think it was on the 12th of April. Biden had conversations and meetings with both parties on either side of the aisle with respect to what the shape of this tax reform, I guess, if you will, may look like in the coming months, or probably sometime maybe towards the end of 21. I think is kind of the aggressive timeline they're looking at. I'm a little skeptical if they're going to be able to get something done that quickly, but it remains to be seen. So currently, as many folks probably already know, we have a 21% headline rate here in the U.S. now. It was reduced from 35, so fairly significantly back in 2017, starting with the 2018 year. There's discussion, at least from a headline rate perspective, of possibly going to a 28% headline rate. There's probably going to be a lot of pushback with respect to that from an anti-competitiveness perspective to go that high, again, into the high 20s. That'll probably take us right back up to some of the higher rates in the world, just like we were prior when we were up there with U.S. and Japan up in the 35% prior to the prior reduction. I know there's a lot of pushback from individuals who are more moderate on the left of the aisle, on the Democrat side, like Joe Manchin and those individuals, that maybe we'll get to a 25 or 26% rate, but it seems like a 28% rate might be a little bit of a stretch. We'll see what happens with that, but that's my own kind of 2 cents. If I was a betting man, I would tend to suggest that we probably do get a rate increase, but it may be somewhere in the mid-20s. 28 seems like it'll be difficult to pass both chambers. There's, as an international practitioner, I think the big thing that is going to possibly affect a lot of U.S. multinationals, both with operations in India or not, is the prior GILTI regime and the changes to that I mentioned earlier in the context of the refunds of any withholding tax. Well, currently, foreign earnings are subject to tax at the U.S. level with a foreign tax credit. And now it's a convoluted computation, and you do it on an aggregate basis with respect to all your foreign affiliates. And the earnings that are subject to tax are the earnings that are only in excess of a routine return of 10% on your fixed tangible assets that are offshore. So the premise coming from the administration currently is, well, this is effectively incentivizing companies to drive investment into the foreign jurisdictions out of the U.S., thereby having a negative impact on jobs and the like. haven't seen that in practice at all. In my practice, I don't, and I haven't spoken with anyone that has. But that's the political talking points nonetheless. And they want to. The Biden administration wants to undo that 10% return. So you would broaden the base with respect to the foreign earnings that are subject to tax, and increase the rate of tax at which GILTI is taxed today. So at today, the headline corporate rate is 21%, but you get a 10.5, or you get a 50% deduction with respect to that income. So you pay a effective rate of 10.5%. They want to raise that rate such that that rate goes up to 21%, and those foreign earnings will be taxed basically double what they're taxed today. So that would be quite the change, and a significant revenue raiser on by the Biden administration for purposes of paying for some of their infrastructure proposals. That's kind of why the whole idea is Made in America tax plan, is the infrastructure proposals and some of the other incentives that I'll just briefly touch on in a moment. So that disallowance of the routine return on tangible assets could be fairly penal to a lot of U.S. multinationals. Also, within the context of the GILTI reform, they want to do away with the fact that it's done on an aggregate basis with respect to all your affiliates. They want to do it on a country by country basis. Well, what does that mean? Well, that basically means that, you know, every jurisdiction, of course, has a different tax rate, and you're paying different rates of tax in those various jurisdictions. They want to prevent credits from a higher tax jurisdiction sheltering income from a lower tax jurisdiction. So you may have an entity, and say, just picking one out of the hat, say Bermuda, that doesn't pay any tax, or you may have another entity in, say, Japan, that pays a very high rate of tax. Some of those credits or some of those foreign income taxes may be used, or possibly used, to cross credit and shelter earnings of the Bermudan entity. So they want to be able to not do it on that aggregate basis and have that construct, and do it on a country by country basis. Excuse me. So it remains to be seen how that will all play out. And lastly, with respect to GILTI, there's an election that folks can make to have, if the foreign entity is subject to an effective rate of tax of greater than 18.9%, you can make what they call one of these high tax elections, and those earnings won't be included currently in your U.S. tax return. They want to remove that from the legislation. They think the IRS and Treasury, when they released regulations fairly recently with respect to that, they exceeded their authority in doing so. And the messaging coming from Washington right now is that is something that's effectively a handout to corporations. So that on the GILTI side is probably, as we think about outbound U.S. companies, probably on the internet, as an international practitioner, one of the big items that we're continuing to monitor and seeing how that is going to evolve. Further, they're thinking about, some folks may be thinking about the export incentives that were granted as part of the 2017 tax reform, the quote unquote FDII deduction. FDII was part and parcel with GILTI because the intent was to drive back investment in the U.S. and intangible ownership into the U.S. for exporters. Excuse me. So when you export property or services, the idea was you get a favorable rate of tax on that. Those earnings that you were earning, again, in excess of a 10% return on tangible property, were considered this intangible income. You would get a deduction, and you pay a favorable rate of tax. Well, they want to eliminate that. Interestingly enough, because they don't feel that, you know, it's had its desired impact from a perspective of jobs and investment in infrastructure and all that stuff in the U.S. And replace it with, we don't have any details, but some type of credit with respect to inbounding activities, manufacturing activities, the like in the U.S. I can't go any further detail on that because nobody knows, but remains to be seen. And I guess the last is, so we think about, folks may have heard about the BEAT provision. They want to eliminate that, which was a provision that really impacts more inbounds than outbounds. So it could be an Indian parenting company with U.S. operations. And then if they have related party payments to foreign affiliates, you can have a situation where the deduction is disallowed. They want to eliminate that and basically replace it with a situation where you would disallow deductions if the payment was otherwise subject to a low rate of tax in the foreign jurisdiction itself. So it's actually similarly. The understanding is at the moment it could be similarly modeled after some of the OECD work that's going on currently, that as part of the quote unquote BEPS 2 in the digital asset space and in the digital taxes that are being looked at. And that construct, the Biden administration in general is certainly much more than the Trump administration, seemingly more apt to be at the table in terms of working with the OECD and otherwise getting to an answer on both digital taxes and some type of global minimum tax. Although, I still think my personal view is it's not going to be an easy road to hoe at all. Largely because there's a lot of thoughts even coming out today from even just European jurisdictions that are on the lower side of the rate scale, the Irelands, the ones that have some influence in the EU. A lot of folks over there are paying a 12.5% rate, and the Biden administration is calling for a minimum tax or a global top-up tax somewhere in the low to mid 20 range, similar to what we'll likely have in the U.S. And those jurisdictions are worried about their competitiveness and their incentive regimes that they're currently providing in Ireland and the like. So we'll see what happens. It's a long way to go. A lot of discussion, a lot of lobbying to be had. Details are, like I said, thin. Certainly staying abreast as to the developments, and I think that's about it on the legislative side at the moment, at least based on what we know.
Yeah, thanks, Jed.
So I think that gets me close to 20. Maybe give you a minute or two back here, but
No, in fact, thank you. You've rather touched everything. I mean, the guilty plea part and the fact that if US has already found some support from France, Germany, and IMF, then it's not very far. Your 28% construct on a global minimum tax, which coincides with the fashionable follow-up, if I may use that phrase, or tailing up to the Pillar 1 proposals on the unified approach, looks like there could be a handshake, somewhere or the other, if the buy-in of the US needs to be on the unified approach, although US is not a signatory to the MLI, but that could
Right.
just help in buying in the whole thing. It's very helpful. I think you've touched on a lot of points, and please stay on because we may just pick up your thoughts on a few questions which we've got in
Sure.
the chat box. And of course, friends, ladies and gentlemen, today is an auspicious day in India, which is Ashtami. Today is also the birthday of Saint Dhanna, Bhagat Dhanna ji. And at our chamber, we are privileged that we've been graced by Mr. Kumar. As I said, he is unflappable in his views, a man of tremendous conviction in his thought process. And as I said, his thinking and his ability to pan out thoughts on first principles are absolutely astounding on at least international tax. I'm sure for the developments which the country has seen insofar as international tax is concerned, which is a subject very close to my heart otherwise also, I think a lot of credit is deserved, and rightly so. Sir, we all are eagerly waiting for your thoughts on the judgment, and I have a lot of notes also, which time permitting, I will request you to share your views, your thought process on being part of that very illustrious group of judges constituted by the Canadian tax court, which I understand is the highest fact-finding court in Canada. So the confidence which you gave us in our prep sessions, despite your heavy board, the fact that you had hearings where ASG and others had to address you, your love and affection, and your being very honest to the brief is very inspirational, sir. Sir, as I said, there are a lot of thoughts which I have in my mind, but first of all, we'll request you for your, as a purist, what do you, as a pundit of international tax, what are your first impressions about the judgment, sir?
Thank you so much. You have been a bit more kind to me than you should have been, but anyway. First of
So
all,
you have to be a little closer to the audio.
First of all, I must say that the views.
Yeah, of course, sir. That caveat I forgot. The views here are your views, and they in any way do not represent the views of the illustrious institution. People, sir, the audience is here willing to hear your views, and you bring a lot of stimulating thought process. So on that housekeeping note, my apologies, sir.
No worries. Thank you so much, Asim. Now, first of all, I must say, Sachin has beautifully explained the decision of the Honorable Supreme Court, and there would be very little to add to this. But then there are several facets to this decision. When you say an Indo-US Dipstick on the recent Supreme Court decision on taxation of software, rather than holding a dipstick and finding out, taking my call on this, I would say I'll see the road traveled and the road ahead. What has been covered by this decision, and what could be the controversies which would still come up before the Honorable Court from time to time. That's how I look at it.
Right.
Now, there are several facets to this decision. First and foremost is the detailed analysis of what copyright means under the Indian Copyright Act. And what is held is incredibly simple. Unless there's a transfer of copyright, it will not tantamount to royalty under the DTAA or under the Income Tax Act. Now, what will amount to transfer of copyright, that is what their lordships have discussed in great detail. It's almost like a thesis. This decision is probably more relevant from the point of view of what the copyright law in India is. And this is the way their lordships have looked at Section 14 of the Copyright Act, Section 30. What is the impact of this? Some words being deleted in a section, what you call kill effect, and then what is the overall situation today? But I would find myself to a few things about the peculiarities of treaty interpretation, and that's the aspect I'll add a few words on. The first question, which I think is a very, very significant question, and that is the question that Honorable Supreme Court has considered at length, is to what extent you can lean on the domestic law for interpretation of undefined treaty terms. And on one hand, you have Article 3.2, and on the other hand, you have explanation 4 to Section 19. Now, before I come to this question, it is very significant that Honorable Supreme Court has taken a look at the 2012 amendments and held that how these amendments could only be prospective. Therefore, to that extent, the domestic law is read down. Now, the question arises, what happens from 2012 onwards? Now, instead of looking at 3.2, their lordships have read down the domestic law itself, and we have found a solution. The litigant is happy that he got the relief that he was looking at. But there was a fundamental question. And that is a question which will probably need to be dealt with very, very briefly to understand as to what is waiting ahead. Now, Honorable Supreme Court has given large variety of reasons about why these amendments could not be retrospective. And I'm sure it's a great learning point for even the government of India to be very careful with the words like for the removal of doubts. Only a vigilant and fiercely independent judiciary like Indian judiciary could have taken the call the way their lordships have taken. The lordship did not miss the fact that the word computer itself did not find place in the Copyright Act till 1994.
Yeah.
And similarly, the words transmission by satellite, optic fiber, or similar technology could not be introduced with effect from 1976.
Right.
When the control legislation itself was introduced in 1995.
Right.
I mean, this is absolutely perfect, and that's where I would heartily, I would say this is one moment when you feel proud of being a part of the great Indian judiciary, where you have the honorable courts which take such fiercely independent judicious calls. But today my question is far more fundamental. My question is, when you look at the memorandum explaining the Finance Bill 2012, and which their lordships have reproduced at paragraph 75, it takes note of the fact that there are certain judicial precedents, and that considering these judicial precedents and to restate the legislative intent, the amendments are being made. Now, this is the terminology used in the memorandum. But in simple English, it means to nullify the judicial ruling in favor of the taxpayer, this amendment is being made. And that's what I'm concerned about. Now, clearly, therefore, the amendment were to nullify the judicial precedent as it prevailed at the point of time when the treaties were entered into. Now, what we have done by the amendment is that the conclusions that would have been arrived at on the treaty provision is now altered. And that has been done unilaterally. The question is that whether this kind of an amendment in domestic law by the government can be said to be implementing the treaty in good faith. And if not, what follows? Now, remember, interpretation, there's a consensus by now in the decisions of all of the honorable high court, all the honorable courts, including honorable Supreme Court, that even though VCLT, the Vienna Convention of the Law of Treaties, is not really binding, this is to be respected, and by and large, is to be adhered to. Now, if you look at Article 26 of the VCLT, Article 26 says, every treaty in force is binding on the parties to it, and then come the crucial word, it must be performed by them in good faith. Now, can an amendment to nullify the impact of the treaty be said to be an amendment in good faith? Now, if not, then what would follow? It's not a question of striking it down. The solution is within the treaty itself. And that solution is in Article 3.2. Now, what does Article 3.2 say? Article 3.2 says that unless the context otherwise requires a term not defined in the treaty, shall be the domestic law meaning will be adopted. But then there's a huge controversy. And the controversy is, do we take the static meaning or we take the ambulatory? There have been cases, the consensus seems to be that ambulatory meaning is to be adopted. And that's how the honorable courts have seen it from time to time. Bombay High Court, in the case of Siemens, for example, their lordship said, no, you have to take the ambulatory meaning. You can't take a static meaning. But then, in one of the decisions, which I had an occasion to write in the case of Reliance Jio, the case was made out that taking ambulatory meaning is not a universal rule. There can be situations when particularly when the amendment law is triggered by the reasons which come in conflict with Article 26, then static meaning can also be adopted. Now, my disappointment with this judgment is, of course, this judgment which has made everyone happy. Government is happy that there is certainty. I'm happy. ITAT as an institution is happy. Taxpayers are happy. But the disappointment is that the whole debate about the static versus ambulatory is simply, I would say, brushed aside or is buried because taxpayer got relief on some other count. Now, this would become relevant when you look at the post-2012 situation. Up to 2012, no doubt, the amendment which were made cannot be taken into account. Well, what happens post-2012? Now, can you say that post 2012 we will take the ambulatory meaning, or you will take the static meaning? I think that's where the issues are still open. I see you're trying to say something.
No, it's just that your thoughts are so provocative in terms of few interventions I had, but I would refrain and would urge your lordships to continue for a little while. Then probably the few pointers I have, because the role and influence of treaties and domestic law on design of each other is very important, and the ubiquitous threshold link between DTAs and domestic tax law, which consists of typical things like Article 3.2, which looks at the domestic meanings of undefined terms with that qualification. And also, sir, let's not forget the handle which the income tax legislation has in terms of Section 90, the beleaguered explanation 4.
Explanation 4.
Yeah.
I'm coming to that.
Yeah.
Now, even explanation 4, because if you look at explanation 4, which is inserted with effect from 2018, the question would arise: to what extent a unilateral amendment in law could impact the earlier treaties? I mean, these are all open questions. Probably, as a student of law, I would have been a happier person if these questions had come up for consideration and their lordships had taken, a call on this and share their pulse of wisdom with us. But anyway, as long as the taxpayer gets relief, everyone is happy. Today, I'm sure for 2012 onwards, it's an open question, and then call will have to be taken as to how to static and ambulatory will play, how the reconciliation of Article 31.1 with Article 26 is to be done, and what is the impact of this? What is the impact, to what extent those ambulatory meanings can be adopted? And another fundamental question, you mentioned about explanation 4. This is something also very close to my heart, because what does explanation 4 do? Explanation 4 alters the position in as much as it makes it mandatory to adopt the domestic law meaning.
Yeah.
But please understand that even without explanation 4, one could have taken domestic law meaning under Article 3.2. The rider was that it has to be in the right context. Now, what will decide the context? The decision on context has been a lot of other factors, and I'm sure BCLT provisions would be one of them. The background in which the amendment has been made one of them, and that call is also at one point or the other is to be taken as to what is the impact of explanation 4 to Section 90 as a feature of the Income Tax Act. ITAT happily applies it. It's not for us to question it, but I'm sure if this is an issue which is given attention by the Honorable Supreme Court, that would clarify the position to all of us once for all. Another very important point that comes to my mind is that what are the principles on the basis of which the tax treaty interpretation is to be done? Their lordships have talked about OECD commentary. Very good. They have referred to 3 judgments: Azadi Bachao, Formula 1, and e-funds, in support of the observation that it is consistent with stand that this is to be adopted. And then they have referred to a judgment of Australian court, which was referred back in 144 ITR in Shakapatnam Port Trust, that is international tax language. But then that's not the only principle on which it is to be decided. Now, how do we treat when you say that a treaty OECD commentary is to have a persuasive value? Now, how does persuasive value come? In one of the decisions which I wrote way back in 2013, right florist case, right. I think I mentioned that it is some kind of a contemporaneous expositio, in as much as a OECD commentary reflects what those people who introduced these provisions meant by these provisions. But then the next question is it binding? And is it the only thing? Now, take for example the case of the Morocco Treaty. Their lordships have mentioned about Moroccan Treaty. Their lordships have mentioned about Gladden's case of the Canadian Federal Court, where they said you have to implement the true intention. But now, when you refer to Morocco Treaty and you read the judgment in the case of engineering excellence, you will find that if the copyright is to be, if you read the Moroccan Treaty post-amendment 12.3, Article 12.3, which specifically mentions about computer software, but since copyright word is mentioned before, going by the present judgment, even though world computer software is mentioned, it may not, one could take a view that there is no transfer of copyright. And then comes the conflict. Now there is a conflict between the OECD commentary and the intention of parties. What would prevail?
So just a thought here. All these days, since yesterday, in fact, as I was apprising you over our prep call, that yesterday onwards, the UN started its 22nd round of the tax committee, which is, of course, a group which gives a lot of advice to UN, and finally their recommendations finally see the light of the day, and we have this green book, sir, which is UN model commentary. And I will come to one trivia also towards the end. Now, Article 12, there is a draft proposal within the UN to include computer software, and in this round of discussions which are going on this week, there will be a discussion on inclusion of computer software in the UN model commentary in Article 12. I was just thinking, and perhaps your views on this, that would have been more equitable for their lordships to have looked at what is happening apart from the world of OECD and championing the cause of OECD, to look at what is happening otherwise also. I know UN is like a child of lesser god, thankfully it is funded by India, Norway and the European Commission. Otherwise the UN tax subcommittee may not have gained so much of traction which it has done. And in June we are expecting some new sort of publications on the transfer pricing side. On yesterday, sir, we did discuss on dispute resolution, a new handbook. And even today also, sir, the deliberations which are going on between yesterday and today is somehow to see the dogfight of Article 12B. So, I mean, all in all, do you think that only looking at the blue book of OECD was the most appropriate thing? I mean, I know we are having this discussion largely in an academic exercise. So
there are two problems, Asim. The first thing is we must understand that OECD is the only intergovernmental body. Unlike OECD, the UN Tax Committee is only a committee of experts where people come in their individual capacity. It's not an intergovernmental body. So I don't think really this represents the will of even the member countries, because right, even though they have nominations from different countries, our own one joint secretary is there as an expert member, but he's there in individual capacity. So right, I wouldn't say, comparing UN and OECD, they don't stand on an even ground. That's one thing. But I agree with you in principle, and that's what you mentioned to me another day also, that there seems to be a vacuum. In the sense, there's no think tank available apart from OECD. And OECD, we all know that they have a tilt for the, for the residence countries. It's not a state secret. So therefore, I agree with you that when you look at the OECD commentary, you probably also need to look at the other interpretations, including the interpretations given by the UN, even though UN interpretations are also by and large adopted from the OECD. They extensively quote from this. When you attend both the meetings, OECD and UN, which I'm sure you have seen both now, there are common faces which are popular. They wear the hat of the UN and they do the same job, and they wear the hat of the OECD and do the same job. So two small points I must make before I wind up. That first thing is, what is the persuasive value of the OECD comment? To me, it's nothing more than a ready-made analysis. And when the honorable court say that it's high persuasive value, it probably means that unless you discard that meaning, then you can't adopt another one. So when you think of the reservations, if you look at this judgment, somewhere in the judgment they've given an example about what are the reservations, and these reservations fall in three categories, even in the judgment in the case they have given there. First, where they express a reservation about right to tax. Second, they express a reservation about right to define. And third, they express the position that this interpretation is not an appropriate interpretation. Now, these reservations have nothing to do with the model text treaty convention as such. It's only dealing with the interpretation. Therefore, and one point which was made by someone a short while ago, I think Sachin made it, that India could have expressed in this categorical way, and then it would have been taken at a different level rather than giving it a vague. Now, please understand, even expressing a reservation in the OECD forum is not a unilateral process. I'm afraid, some more work is required to be done on this with regard to presenting the right facts before the Honorable Court. Because when you have to express a reservation, you make out a case, send it to the OECD Secretariat, and I'm not too sure whether the words which are stated in the reservation are exactly the words as given by the observer country, or these are the words given by the OECD Secretariat. Therefore, if there is some variation in the wording of a reservation, as their lordships took note of, it will have to be seen whether it's on account of the country making that observation or on account of the editing by the Secretariat. Because it's not a simpliciter observation given by a member state which is appended there. So, and then a question would arise that when you say that you don't agree with that interpretation, will the treaty to that extent continue to be in the nature of the contemporary exposition? That is where I think once again the call will have to be taken.
So, now, sir, on a personal note, when you look at the reflections of Supreme Court, and you may not answer if you should not wish to, after looking at Supreme Court decision on expressing a view on the reservations, if you look back para 17 or para 19 of your decision of right florist, do you feel? Yeah, do you feel that at that point in time, and of course, right florist, in my view, opens the door of equalization levy. And I was talking with Sachin the other day that equalization levy now looks to me the service tax of future, which was started in '94 with X number of services and became the real big bogey for all for everybody. And that's going to happen with equalization levy. I mean, Supreme Court in its judgment says, when it looks at Article 30 of the tax treaty on the Indo-US context, which I don't know why the ASD referred, and said you can't have two bites of the cherry, but the revenue will happily have the second bite on equalization levy on this.
No, Sachin, first of all, equalization levy is a temporary measure until the consensus develops on how to tax the digital products. And this is a unilateral measure taken. It's not it's not a kind of a measure which is generally international taxes consensus based. Equalization levy is not consensus based. It's a temporary measure because there's no consensus on how to bring the digital products. I can see we are running extremely short of time. And
Sachin, can we extend it by 7-10 minutes? Is it doable?
Yeah, of course it is.
Subject to, sir, do you have 7-10 minutes?
No, I have no issue.
Okay.
So now, when you say about the equalization levy also, I think, first of all, it is a unilateral step. It is a step taken because there's no consensus developing on the digital products, on how do we do this. And I wouldn't really think that it is a solution, so to say, as soon as the consensus develops on how to develop the entire digital services. Even software is in a way, software on the CD or software in this kind of form is kind of an obsolete thing. Today, you are looking at the different business models, Netflix streaming, on the other kind of digital products. And as Raman very appropriately said in the opening remarks, that the business models of the digitization of business, this is changing all along, and the conventional things will not work here. So there's one thing which really surprised me, and that was I have known the learned ASD for a long time, in the sense that his brother is my colleague, and I've interacted with him several times. And when I saw him taking a stand that in section 195, you don't, for the tax deduction at source or withholding taxes, don't apply the treaty. Apply the treaty only when it comes to final determination. I mean, a person as knowledgeable and as bright as Mr. Balbir Singh, and he takes this stand, so I can only understand the limitations of holding the government office, or the limitations of a lawyer when probably you have no case on merits on substance. But that was something very appalling to me on a personal note. To say that tax deduction at source is divorced from the ultimate tax liability is something very, very incorrect on the first principles. And I'm so happy that honorable Supreme Court has come very firmly on this. They've come down very heavily on this, and there's a linkage into Section 4 and 9. And there's as Jed very rightly said, that now the whole emphasis on how to construct the EULA, the end user license agreement. And as long as the rights are not transferred by the EULA, by and large, the company giving software is safe.
So, sir, I think we should get Jed also into this conversation. Jed, on 8th of April, I understand that US did some presentations on Pillar 1 and Pillar 2 before the steering group of the inclusive framework, which is 139 odd countries. And so far, since October 2019, OECD is trying to drum up the whole Pillar 1, Pillar 2 proposals, and then came the UN 12B, which people in UN are fighting to save it somehow. I can speak firsthand the yesterday's discussion, even after the fact that UN had agreed in its last meeting, still there were some sort of efforts being done to sort of clamp down on 12B. But looking at the big picture, do you think the digital dogfight will settle now that US has decided to stick its neck out?
Possibly. I mean, I've always been personally a little skeptical, I guess, at least if nothing else, of the timelines that have been put out by OECD. They just always felt a little aggressive to me, considering the nature of the issues and the details of what would need to be crafted for both Pillar 1 and Pillar 2, both the digital taxes and the minimum tax provisions. I do think it'll get going. Certainly, probably a little bit more downhill now that the administration has basically given the indication that they're willing to play ball and work with the OECD to get to some kind of a common ground in terms of the digital taxes. I mean, it's certainly more amenable to coming to an answer and not the hard line stance under the prior administration, where this is really just a penalty, an attack on US large multinational technology companies, the Googles, the Apples, the Amazons, all the big players. There's not that level of, I guess, US corporate protection, or however you want to phrase it, currently, I think, in the administration. So while I don't think they'll give away the farm by any means, I don't get the impression that they're willing to just roll over and go along with anything the OECD does. But they certainly do seem willing to really start to have a significant dialogue, in particular on Pillar 1, because I think that's the one where Pillar 2, I think, remains to be seen, and that may be, I think that was always kind of took a little bit of a backseat to Pillar 1, was the digital tax and the need to get some common ground with respect to that, so you didn't have individual nations kind of going rogue and then have difficulty complying and the like with respect to different regimes. But yeah, it seems kind of a long-winded way of saying I think it will go a little bit further downhill from here without question. I think, to your point on whether it was the 8th, I think it must have been the 8th or whenever it was, and there was a recent statement they gave. I think it was even Janet Yellen, I think, gave a statement too, or I think maybe it was in the form of a letter to the OECD, indicating a willingness to play ball and move it forward and get to an answer. So. We'll see. I think the big thing, I think we'll get there at some point. The timelines, to me, just, I think they're going to keep getting pushed out. So we'll see what happens, but we'll probably get to something, but it may be a little bit longer than what they otherwise expect.
Great. Sir, you mentioned about Article 3.2, and I understand, sir, Article 3.2, was first used in the US UK Treaty in 1945 in the backdrop of the Canadian US Treaty of 1942. And of course, authoritatively, you've cited the Supreme Court Melfort decision, in the Reliance decision also. Looking back, sir, at the Reliance decision, which was dispensed 2 years ago by yourselves, and when you look at the Reliance decision, I won't, I mean, I don't want to cite para 21 and 15 for the sake of time. And now you look at the whole approach of at least possible approach. Do you think Article 3.2 will get justice in times to come? And how satisfied you feel about your thoughts? Of course, I know for a fact that excellence has not done what perhaps one would have expected, because the relief, as you rightly said, pragmatically was forthcoming.
Absolutely. I think instinctively their lordships were right, without going into the technicalities of this route which is followed in Article 3.2. And to be honest, I'm happy that they have not even bothered to look at whether to take a static or ambulatory. They have taken what is right without getting into the debate. But since there is such a huge debate on whether to take a static or to take ambulatory, and if static to what extent, then I think I would personally think that Article 3.2 is going to come up in litigation in times to come before the honorable courts above. And an authoritative call is required to be taken one way or the other about how flexible we have to be in our approach to Article 3.2. And let me tell you, the first time that I wrote a decision based on Article 3.2, that was way back in 2005 in the case of Hindalco Industries. And that was the case when the connotation of properties came up.
Yeah.
And I said, no, I'll not adopt the domestic law meaning because it defeats the purpose.
Yeah.
So I will keep my fingers crossed, and I look forward to what the honorable courts above have to say. But Asim, just one small point I have to make on 12B, and yeah. I'm wondering what is the take of Jed. Is there really support to Article 12B internationally, and is it seen as something which is a bit too early? Because you are required to take a holistic view on the entire digital services and products. And the 12B as it is now is not by an intergovernmental organization. It is by a committee of experts, more like an academic delight, I would say. So how do other countries take a look at 12B, and what is support we have on this?
So I can only speak as latest, as they say, fresh from the oven, is what deliberations which took place yesterday. And I can tell you that as an observer, we were invited, but it was, to say the least, that it's trying to save somehow Article 12B. Everywhere the effort is to sort of claw it back one way or the other, and it wasn't a very happy feeling. And I'm sure even today's discussion and next week are somehow going to, I mean, the effort is on to somehow claw it back as much as it can. And if you look at the amount of the serious minority view on Article 12B, which is being expressed in the model commentary, I mean, I'll keep my fingers crossed. I mean, I'm not very optimistic about it, but I understand the efforts put in by developing countries, including by India also. But the reality of the matter is that it wasn't a very happy day yesterday, spending 3 hours on it. And just to tell you, none of the observers made any intervention. I think we were all so dejected by the end of the day that it wasn't a very good feeling. Sir, before we wind up for the day, I have a small trivia for you. And pardon me for this, but just a small trivia. Sir, do you like the blue book, which is the OECD model commentary, or do you like the green book? Or do you think India should have another book of its own model commentary, and perhaps your wisdom on the tax treaty interpretation law, which many common law countries like Canada has?
I have greatest respect for both the books, but as you would have seen probably even in my orders, I don't take these books anything more than a ready-made analysis by some experts. In the case of Nokia, when I was writing a dissenting opinion, and while starting that note, I knew I'm in dissent because my colleagues had sent me a signed order by two members. I said, this is a view which is there, but I don't agree with it. So I have highest respect for both these books, but then I have even greater respect for my own judiciary. And I have greater respect in the wisdom of the judges of the honorable courts above. And I would think that the time has come for judiciary to be very proactive on this not to take these interpretations or these commentaries as not to put them on such a high pedestal as to give a break to our own thinking on the subject. And that's how I look at it. I'm sorry, and I do personally feel that OECD commentary has a lot of tilt towards the residence country at many places. That apart, it is an excellent academic analysis, and that's how it should be taken.
Right. Sir, thank you for your very frank and candid views, and please promise us that if we were to request your and encroach on your time, you will allow us to do so. With this, I think we've overshot by 10 minutes, but sir, it was a treat, as I said. And Jed, any concluding thoughts before I ask Sachin to do the honors?
Asim, there is one question which has been addressed to Jed. So if you could please read that, or if you want, I can.
Yeah, please read it.
So Jed, there is one question for you, and what is being asked is that what do you think will be the impact of Biden admin actions vis-a-vis American companies outsourcing ITES services to Indian service providers? Will it increase or decrease?
Yeah, I responded to that in the chat too. I just saw it in the Q&A. But yeah, I guess on that point, really quickly, it depends. That's the typical tax answer, right? It depends. I don't. If third-party outsourcers, I don't believe there should be any impact. So if U.S. companies engaging a third-party Indian outsourcer, it should be fine. So I don't think they'll be really impacted at all. The potential for issues on the U.S. side can come up, when you have controlled related party transactions and people either trying to erode the U.S. base and making payments to India and whatever the case may be. I think on the third party side, it's probably to be fine. I mean, currently today, related party outsourcers, if they're using in-house, related party entities that have some kind of outsourcing, or even just a, some kind of, a lot of times there's R&D, whatever the case may be that's going on in India that the company may be using. And that today already, you have to look at it in the context of things like BEAT anyway. So depending on the company profile, you may or not have implications with respect to that activity. And we'll see if any provision that possibly replaces BEAT could have any further impact on that that U.S. construct, where a lot of times they're setting up related party entities for either it's IT outsourcing, other shared services, contract R&D. There's a lot of that going on. So we'll see if anything that replaces the BEAT provision that could have further have implications for that as well. But unfortunately, there's no good answers at the moment.
Thank you, Jed. You pretty much reminded me of my professor at Harvard, Joe Rosengard. Anyway, Sachin, over to you for the honors, and yeah.
So it's a great honor for me to propose a vote of thanks to a panel as learned as we've seen today. Pramod Kumar sir, we are really grateful to you to exceeding our request, and as Asim mentioned, we would surely encroach upon your time, and we hope that you would accede to our request. Jed, thank you so much for taking out time and to be a part of this webinar. Your views, I think, were very, very stimulative, and I hope the participants benefited. Thank you to our sponsors, to the Secretariat, and last but not the least, to the chair of this committee for moderating this session such beautifully. Thank you so much. And
watch out, the Google judgment is on the anvil. We will huddle very quickly. The Karnataka High Court has set aside the judgment.
And once again, I would just like to wish everybody good health. Please stay safe, and let's hope that together we will surely overcome these difficult times. Thank you.
And thank you to Taxman as
Thank you,
as
sir.
the channel
Thank
partner.
you so much. Yeah.
Thank you.
you.